See.
Good morning. Doing well, how are you?
It's racist.
I did. Well, I slept wrong or something, because my dad says I have a habit of doing this, and this is bad for you. Like, you get cramps in your arms from doing this. Good morning. How was last week's one?
Much needed, checking up over this.
It's
This is the gunshot. Any case not.
Thank you.
We word on the fly later.
Nice to meet you.
Whoa, there it goes. Good to see you.
Yeah, fingertips.
Nice to meet you. Nice to meet you. Nice to meet you.
Yeah, fingertips.
Oh.
All right.
You can be seated, thank you. I have to say, I got less motions than I thought I'd get from the two of you over the weekend. Make sure I have the correct two. Francis has a motion for directed verdict and Sassel has a motion. Is that right?
That's correct.
Okay, anything else I'm missing?
We filed a response to theirs and a reply last night, but I suspect, given the timing, you did not get it processed, but I have a paper copy if you'd like.
If you bring that up, I'd appreciate that. I have not seen those yet. Thank you.
We also had a response and some of them that we filed yesterday. Did you get that?
Don't think I've seen anything other than the initial filings, but let me see if I have it online in the last hour or so. No, I've not received anything else.
Okay.
The charge.
Yeah, we did it before we left yesterday.
Oh, perfect. Okay, perfect.
I'm gonna check who it was sent to in case.
Be ready to go, girls.
So for this one, would y'all mind emailing me y'all's charges, whichever version you're using?
We
So
did.
I forward them to my team.
We did. We emailed the Word version yesterday.
To me as well, or?
That a good question.
Yeah.
You should have gotten it.
Yeah, we,
Might be at the loading dock, Ms. Shannon.
We sent it to Ms. Travis yesterday, but.
Yeah, we were told, we were told Ms. Travis, I think.
Oh, we already have it because we made this. I'll just forward it. Let me see the.
Thank you, I appreciate it.
I have them, Abby, if you don't.
Oh, thank you.
Yeah, this is the new, the updated version. This one. Okay, gotcha, okay.
Vilma's sending it right now to you.
Thank you.
You gotta learn to walk faster. That's not. Wow, that's a different side. I see your point, but I'm happier when they're just not here at all.
No.
Yeah. I thought- I can't believe it.
He's not my stuff.
I don't know, I couldn't. I was like, they kept gathering. I had to ask.
Yeah, I had ego. And you guys who-
All right, thank you for your patience as I read those. You ready, Abby?
Yeah, Martin is good. Okay.
Need a clean copy of those.
All right, we're back on the record. Francis versus Sassel. Would the parties please state their appearances for the record for purposes of today?
Yes, Your Honor. This is Byron Alfred here along with co-counsel Johnny Alfred, George Gore, and Peter Beard, as well as additional counsel Art Gedgy, as well as Elizabeth Butler on behalf of plaintiff Justin Francis.
Thank you, sir. Yep,
Kevin Yankowski and Peter Tibbs with Norton Rose Fulbright, along also with additional counsel, Mr. Brian Cathy, on behalf of the defendant Sasol Chemicals.
All right. You both have filed motions for directed verdicts and related responses and replies and supplements. I'm going to begin with Sassel's only because that was given to me first last week. So why don't you tell me what you want me to do and why?
Yes, Your Honor. We have 4 grounds for directed verdict. I'd like to specifically call the court's attention to 2 of those. The first being gross negligence, and the second being the issue of contractual control. Before I do that, I'd like to provide kind of an overview, starting with where we started in voir dire, and that's the issue of a red herring. The plaintiff's response and most or all of their complaints, including their claim for gross negligence, is predicated on the contractual requirement that Savage provide a remote control locomotive of their choosing. As I'll address in connection with the contractual control, that's a typical provision that is required if you're going to price any type of contract. It wasn't a mandate that they only use a specific type of remote control locomotive. It was simply an allocation of responsibility and a pricing term. That's not a relevant type of control. But even if it is, there's still multiple safe options that were available to Savage and its crew members to use a remote control locomotive. To start, Sasol didn't control the type of locomotive that Savage selected. As the court will remember, we heard testimony that there were other forms of remote control locomotives, including ones with essentially a speed control option that would allow use of 4 points of contact while even if you were riding a remote control locomotive. Different places to operate a remote control locomotive. The theme from the plaintiff has been that it would be safer to operate a locomotive from the cab or the engine of the locomotive. A remote control can be transferred anywhere. You could operate it from the ground, which we heard was the safest option. You could take that and operate it in the cab just as a conventional locomotive. So if Savage thought that was the safer option, that option was available to them. You also heard testimony, different places to stand on the rail car. So even if you elected to ride a rail car, there's different places that Savage and its crew members could have stood. Inside the gauge was improper, but you still could have stood on the stirrup outside of the gauge and safely operated the car. In addition, regardless of where you stood, it was solely up to Savage and its crew members to select the number of points of contact they maintained and how forcefully they maintain those points of contact. We heard from the only biomechanist that even 2 points of contact should have been sufficient to avoid falling from the train. And so all of these were safer available options that were open to Savage and its crew members. And all of them in each instance was selected by Savage and its crew members without any input or guidance from Sasol. And so I think that is the critical defining feature that animates or really undercuts a lot of the plaintiff's arguments in this case. Is Savage and its crew members independently selected the least safe options in all of these instances without any input or guidance from Sasol. So when you turn to the motion for directed verdict on gross negligence, as the court knows, that's subject to a higher standard of proof, that being clear and convincing evidence. That mandates obviously a higher burden of review for the court. And so when the court's looking at the familiar objective, subjective thresholds, it obviously has to consider that higher burden. And so I won't belabor the points of objective and subjective, but as the court will recall, objective requires an extreme degree of risk when viewed from the standpoint of the actor at the time of the conduct. So this has to be a prospective looking risk assessment. It can't be done with the benefit of hindsight. And in this case, the plaintiffs say essentially that riding a rail car is an objectively, entails an objective extreme degree of risk. But the only way they can plausibly maintain that is if their own client was grossly negligent. When you actually look at the conduct at the time of the occurrence, there were no Sasol employees at the scene. They didn't witness this conduct. And certainly they didn't perceive some objective extreme degree of risk associated with this particular incident because they weren't even out there at the time. The plaintiff was the only person who undisputedly was present at the time of his fall. And separately, you need subjective knowledge, basically knowledge of a peril, but extreme indifference to it. There's absolutely no evidence of any indifference in this case. As the court will recall, that you've heard testimony that the decision to switch to RCLs, which again is a red herring, but that decision was animated by a concern for safety and moving the employees off of the train. And so this case demonstrates the absence or the opposite of an extreme degree, is an extreme indifference to safety. Sasol switched to remote control locomotives and precisely to improve safety, and there were no other incidents. The court didn't hear evidence of any incident in between the switch to remote control locomotives and this accident. All of the other incidents that were discussed involved switching and other things unassociated with the particular remote control locomotives that are at issue. Separately, Your Honor, with respect to corporations, the doctrine of respondeat superior doesn't apply to gross negligence. In order to be grossly negligent, a corporation itself must be grossly negligent. That entails the act of what's been termed a vice principal level. So that's somebody with authority to hire or fire. There's not been any evidence that anybody had authority to hire or fire. Sat through the entire trial. There wasn't a single question about the authority of the individual at issue. In this case, the plaintiff's petition doesn't identify any vice principals who acted with gross negligence. And to the extent they attempt to identify them in their response, they point to Mr. Lee, for instance, who assumed his position shortly before this accident and demonstrated no extreme degree of indifference to anybody. And certainly the plaintiff, even if the plaintiff's testimony is that his prior riding of the rails was observable to certain Sasol employees, that doesn't mean that they actually saw it. You could speculate, but speculation is not evidence. But separately, it doesn't demonstrate that they were indifferent to a particularized risk that would befall the plaintiff. There's no testimony that under those instances, these workers were riding inside the gauge, that they weren't maintaining sufficient points of contact. And so again, there's just been absolutely no evidence that would support any award of exemplary damages in this case. And so that issue should be removed from the jury's consideration. And I understand there's hesitancy sometimes for courts to grant directed verdicts, but this is one of those instances, especially with gross negligence and exemplary damages, where it's appropriate because it influences potentially the themes and the arguments that are advanced in closing arguments. And so it's one of those things where when the skunk is thrown in the jury box, it can't be undone on a JNOV. And so for that reason, Your Honor, we would respectfully ask that the court grant a directed verdict on gross negligence. I can turn to the other issues if you'd like, or we can, the other side can respond issue by issue.
Well, why don't we go issue by issue? So Mr. Elford or whoever's going to talk about gross negligence, tell me why I should not grant that directed verdict.
Just 1 second. Could I take just 30 seconds to fix a technical issue? I'm so sorry.
Yeah, that's fine.
You can go ahead, Mr. Elford, when you're ready.
All right, thank you, Your Honor. To respond specifically to the motion for directed verdict on our gross negligence claims, I'll first respond to the definition and proper definition as I see it, with respect to the vice principals that we've alleged are attributing the gross negligence to Sasol Chemical. The definition that we rely on is it actually requires that a person have the authority to employ, direct, or discharge an employee of Sasol Chemicals. And also the vice principal it requires that Sasol has confided to that person the management of the whole or department or division of the business of Sasol Chemicals. We've identified two vice principal witnesses in this case who both testified live in this trial. The first being Mike Curligan. The jury heard that Mike Curligan was the senior manager overseeing the entire rail logistics department, and he was involved in the decision-making process for that entire department. That's cited in the trial record on the 23rd of March from pages 28 to 29. Our jury also heard that Mike Curligan knew about the extreme risks associated with ride and rail cars. The court will recall that Mike Curligan was the person who sat in that chair and told our jury about a fatality incident that occurred in 1999 involving a worker that was riding a rail car. In fact, he told this jury that the entire purpose for bringing RCLs into the plant was to remove workers from riding rail cars. But in light of that, there were no imposition of any kind of prohibitions of riding rail cars, which is precisely the reason Mr. Francis was injured on the day of our incident. The jury also heard that Mike Curligan was the only person that could have made the decision to transition from RCLs to conventional locomotives in the weeks leading up to the incident. Richard Lee said that on the 25th of March, and that would be on pages 19, beginning at line 23 through 20, ending at line 24 in the trial record. He also, despite this awareness, Mike Curligan showed the deliberate indifference by, again, failing to prohibit the practice and requiring that Savage continue using the remote control locomotives in spite of their request to move away from it 6 weeks before this incident. Our second vice principal witness would be Richard Lee himself, who testified that he was the highest ranking employee of the logistics department at the specific plant where this incident took place. And that would be found on the trial record, on March 25th trial record, beginning at page 18, line 8, ending at page 20, line 24. The jury also heard that in the weeks leading up to the incident, Richard Lee was personally approached at a safety meeting by Savage management employee who requested to switch from RCLs to conventional locomotives. He also told the jury that Mike Curligan was in attendance at that meeting and conceded that he informed Vice Principal Witness Mike Curligan about that request following the incident. And again, that's cited from pages, trial record pages 19, line 23 through 20, line 24. Clearly, there is the entire basis of our claim is the warning that Sasol brought in and a prior knowledge that they brought in of the dangers of these remote control locomotives. Opposing counsel made mention that there were other options available to Mr. Francis, or that to somehow say that Sasol was not in complete control of the RCLs. The fact is that the only way that the rail cars were allowed to be moved in the Sasol sit yard at the time of this incident was by a remote control locomotive. Sasol was the company that provided the switch list. You heard from expert Brandon Ogden that the reason that Mr. Francis was knocked from the rail car was due to slack forces. They cite to the only biomechanics witness in this case. She sat before our jury and told us that she didn't know what slack forces were. She didn't have any, in her opinions, any reference to the slack forces or the buff forces or any of the stuff that the jury had heard about as being the causative reason why Mr. Francis fell from the actual rail platform, from the rail car platform on the day of the incident. Put plainly, the consist of trains, which was there was difference in the relative weights between the rail cars. Brandon Ogden testified about the difference between these rail cars having everything to do with why there was a specific jerk on the day of this incident, and ultimately is what caused him to fall. That was solely due to the switch list that Sassel provided to Mr. Francis and the rail car that Sassel decided that Mr. Francis needed to be moving at the time of this incident. He was required to move that rail car by remote control locomotive, despite the fact that his company had been in meetings prior leading up to this incident, requesting not to be required to do so. There's also testimony in the trial where Mr. Francis noted that Vice Principal Witness Richard Lee, who himself testified to being at the shipyard at least once a week, he was testified to have been present and witnessing workers riding rail cars in the shipyard. He also admitted to witnessing workers riding rail cars outside the shipyard in the months leading up to him becoming the logistics manager at the time of this incident. There is more than enough evidence in the record for our jury to have determined that there was a deliberate indifference or of an extreme risk by the vice principal witnesses that we've identified. We've cited to no less than 50 record citations throughout our briefing, and the jury, certainly having sat through weeks of this testimony, is in the best position to make this determination. So we would ask that the court allow for the claims of gross negligence to proceed and deny the motion for directed verdict on that issue.
Have a response?
Just briefly, Your Honor, the plaintiff's position is logically inconsistent. On the one hand, they say we're grossly negligent for paying the cost associated with remote control locomotives to get people off the trains, but somehow still, we're consciously indifferent to that risk. But the problem with that is we didn't ever approve anybody riding the trains. Savage's own policy was that you shouldn't ride the train unless it was necessary to do so. All of the evidence in the case is that in this instance, it wasn't necessary to do so. And so there's not any approval or authorization of this unsafe practice. And I would note that the plaintiff's own position in the case is that the industry standard is to ride the rail cars and to do it with 3 points of contact. And so there's no position in which the plaintiffs can meet their burden. In fact, they expressly negate it. They insist that what the plaintiff was doing in this instance was safe and that it was supported by the industry standard. And separately, I think I would also address this issue of the alleged warning that Sassel was supposed to provide the plaintiff in this case. We provided the court with the Motton decision out of the Fifth Circuit on Thursday. But essentially their position is we should have warned him about slack forces, which he already knew about, and which the Fifth Circuit says is an open, obvious danger that you don't owe any duty to warn against. And so, and whether that's a premises duty or whether that's an employer duty or whether that is a general contractor, independent contractor duty, in all of those scenarios, there's no duty to tell somebody what they already know. And that is, in this case, the possibility that slack forces, if you don't maintain a sufficient grip, could dock you from a train. And so there's not any conscious indifference to that risk. The plaintiff knew about it. His employer knew about it. They told him is precisely how to ride these cars, which was 4 points of contact and stay off the trains unless necessary. And so there's not any conscious indifference. Instead, this was an instance where Sassel properly relied upon its contractor to do the appropriate thing. Unfortunately, in this case, in certain instances, in certain regards, unbeknownst to Sassel, they didn't do that. But that doesn't rise to the level of gross negligence, and it certainly doesn't express any authorization or any anticipation that this particular accident was likely to occur.
Your Honor, I believe that sounds like a jury argument that is going to be arguing the veracity of the certain facts. We have certainly a different view on the facts that's been set forth in this case. But to respond directly to the Moten versus Union Pacific Railroad case, since counsel cited that case, I believe that the court has a copy of it, but I have another copy of the court.
I do have a copy of that.
Okay, yeah, this case was specifically about It appears to be a child that was only referred to by initials, a minor child that apparently ran or was climbing on trains on a.
He was a neighborhood kid that lived
neighborhood
next to the
kid.
rail
This
yard, I
is, Your Honor,
believe.
this is absolutely inapplicable to this case in the sense that this is by definition, a premises case. It talks only of the premises liability duties, as this honorable court knows. None of our allegations in this case reside in premises liability, and we briefed that extensively in our motion. We brought a negligent activity claim by all stretches of the imagination. We did not plead premises liability, and I think citing cases, and they've cited several premises liability cases to heighten the duty that would be required in this case. Is simply not applicable to the facts of this case and the case that our jury has heard for over 3 weeks in this case, Your Honor. So we believe that the Lee Lewis construction Harrison case, which we do have a copy for the court, is the applicable standard for this case. And in that case, it talks about the general contractor, who in this instance would be Sassel, if they exercise some control over the subcontractor's work. They may be liable unless he exercises reasonable care in supervising the subcontractor's daily activities. And that's citing to the restatement second of towards section 414. And it looks to control. And of course, we're going to have competing provisions of control within the jury charge. But again, opposing counsel's argument sounds perfect for a jury argument. They are going to have different views on the facts of this case. Our jury has sat through 3 weeks of evidence. We have presented our case. They have a different view of the evidence in our case, but certainly I don't believe that we have not met our burden to, of course, with the facts being viewed in the light most favorable to the non-movement in this instance, certainly we provided more than enough, more than a scintilla of evidence for the jury to decide one way or another on gross negligence.
Jim, something you want to add?
Your Honor, the only thing I would respond to is on Lee Lewis, the only case they've cited in support of gross negligence. In that case, the general contractor was tasked with authorizing safety harnesses. They put a gentleman on a 2x4 strung by a rope without any fall protection on the 10th story of a building. They specifically authorized that practice for the in-house contractors and the faulty chair that he was sitting on. In contrast, they required their own employees to use individual separate slack lines in an entirely different safety system. So clearly it differentiated between the treatment of independent contractors and employees. It also involved a faulty system and express approval of it. There's absolutely no comparison between that case and this case. This is not a factual dispute. This is a legal question for the court as to whether the facts in this case meet the legal standard for gross negligence, and as a matter of law, they don't. And so for that reason, this should not be an issue where it's submitted to the jury, and the parties are allowed to argue punishment and other things that the jury should never hear.
All right, talk to me about contractual control.
Yes, Your Honor. Two types of control, obviously, the latter being contractual control. You asked about interpretation of contracts, especially any ambiguous ones like the ones at issue in this case, is a question of law to the court. And so this is relevant to the charge. The pattern jury charge specifically has a comment that says contractual control generally shouldn't be submitted precisely because it presents a question of law for the court. And so again, control in both the actual control and the contractual control setting is extremely narrow. This is operational control over the how. It's not supervisory control over the general scope of work or the general ends to be accomplished. And there's no provision in the contract that establishes that type of control. And so when you actually look at the services agreement between Sassel and Savage, it has an independent contractor provision that expressly says Savage is in control of the means, manners, and methods of their own work. The only way to get out from that under the case law is to establish that that provision was inserted as some type of sham or fraud. There's been absolutely no evidence of that. In fact, the first witness through the last witness all confirmed that Savage operated as an independent contractor. They provided the training, they provided the supervision, they provided the equipment. And so that provision on its own face supports the existence or the absence of contractual control. The only other provision that they cite to establish contractual control is the provision in the appendix to the services agreement that expressly says that Savage will be responsible for obtaining, maintaining, and supplying remote control locomotives. Again, if you're going to order any piece of equipment, especially transportation equipment, and the Supreme Court recognized this in Gonzalez, you have to tell the independent contractor what type of general equipment do you want, right? If you want a large piece of equipment moved, do they need to bring a dump truck, flat belly truck? Do they need to bring a cement truck? What is the stuff you're trying to move and how are you going to do it? And so certainly you need to tell the independent contractor in general terms, the class of equipment that is at issue. And that is all the provision in the appendix does, is it says, Savage, you will furnish a remote control locomotive. That's not a relevant type of control. That is a pricing term. Because if they provide remote control locomotives or conventionals, obviously the pricing is different and other things. And so it's simply an allocation of responsibility provision. It's not a relevant type of control. And as I started out, under that provision, Savage still could have obtained whatever type of remote control locomotive they wanted. If they wanted this new quote unquote state-of-the-art remote that entailed speed controls that could be operated with 4 points of contact, they were well within their contractual rights to do that. And so the control doesn't relate or extend to the operation of the remote control locomotive. It simply is the same type of supervisory control that's necessary in any contractual arrangement. And the only other point I would add on this is they also in their supplemental response point to the Kansas rail lease terms. But those provisions have absolutely nothing to do with this case at all, frankly, and certainly not with contractual control as between Savage and Sassel. There's a provision at the very start that specifically says contractor shall not be defined as anybody who brings their own equipment and is working on their own equipment. Savage was required to bring the remote control locomotives. That's what they were operating on. They don't even qualify as a contractor under that provision. But separately, when you actually look at what that contract says, it's governing the construction and the expansion of the rail yard. And so in the lengthy lease agreement, Sassel is promising to basically expand certain lines and add certain switches. And within that context, essentially, it's establishing what's called a knock-for-knock indemnity. Kansas, you're going to be responsible for your employees and contractors. Sassel will be responsible for our independent contract or for our contractors and employees. It's an allocation of risk as concerns the construction of those additional features in the rail yard. It in no way entails that the parties cannot individually and separately contract with other entities for control. And so I think that lease agreement has no place in this discussion at all. But even if you do, when you actually look at it, it doesn't support the existence of contractual control in this case. Savage said it was an independent contractor. All of the evidence demonstrates it's an independent contractor. And so that issue should be removed from the jury's consideration. And we respectfully ask that the court grant a directed verdict on the issue of contractual control.
Mr. Ilford.
So to dive in, we briefed between pages 4 through 6 of our motion, the entirety of the evidence that would substantiate our claims for contractual control. First and foremost, the court does not require that it's not required, no case law requires it to be a sham for this court to find contractual control. The court is the gatekeeper that's here to harmonize the entirety of the contract. And our contract in this instance in Harmony mandates the usage of remote control locomotives. With respect to the provision that my co-counsel or opposing counsel cited within the agreement between KCS and Sassel, it specifically states that Sassel shall be solely responsible for training and overseeing its contractors and agents as to proper and safe work practices to follow within the SID yard. On page 5 of our motion, when I approached their vice principal witness, Mr. Mike Curligan, with this specific provision, I have a screenshot. This is on page 53. lines 1 through 7 of the trial record of March 23rd, 2026. Our jury heard me approach Mike Curligan about this, and I cited specifically to that provision, read it to him. It said 14.6, SASL shall be solely responsible for training and overseeing its contractors as to proper and safe practices to follow when performing any work in connection with this lease. SASL promised to make sure that everything was proper and safe at the city yard, correct? And Mike Curligan answered, yes, correct. Specifically relating to that provision of the contract, which he testified that he had a hand in negotiating, Your Honor. Additionally, the contractor's SH&E handbook should be harmonized with the agreements in this case as providing the right to control as required under all of the controlling case law, including Lee Lewis construction. It says additionally, SASL through its contractor's SH&E handbook at provision 6.1.15, it stated that it is understood that all contractor safety representatives and safety programs are subordinate to SASL safety. Again, the contractor's safety rules, as they've cited, was specific to remote operations. In the SASL specific documents, it actually provided instructions on how to ride the tank cars while operating the OCU, standing on the platform outside the gauge, face the direction of the movement while maintaining 3 points of contact at all times. Again, this is in evidence, and the jury has heard this evidence. The contractual control provisions within the KCS and SASL contract is a part of the story in conjunction with the contractor SH&E handbook, which the jury has seen, and also with the SASL site-specific documents, which the jury has seen. That's the right to control. That's what the pattern jury charge provides for, and what the jury will ultimately be able to decide if they've seen sufficient evidence of. And we provided record citations. The record is replete with evidence substantiating the contractual right of control. So again, to respectfully to get up and argue against certain evidence and to say certain evidence should be seen this way or should not be seen a certain way, that's just simply not appropriate for this stage of a directed verdict. The jury has heard evidence with respect to the contractual right of control. We provided more than one different provision of the contract that could provide this level and sufficient level of control. And we think that we certainly met our burden, again, with the facts being viewed most favorable to the non-movement, which would be us in this instance, Your Honor. So last thing I'll respond to before I take my seat would be a reference to some provision within the KCS agreement that says if you use your own equipment or maintain your own equipment. Your Honor, that provision is not, that was totally misstated. That's not what that says. If anything, there's an ambiguity that's created by a provision that they've cited to in their 8 p.m. filing last night. Does not reference equipment at all in that motion or in that provision. Does not reference maintaining equipment. It cannot be read to apply to Savage, who was a switching operations provider that we're using RCL. That's talking about a property. And of course, the actual contract provides for building property on the city yard that's being leased, including the wash bay and things of that nature, which they contracted with other people to do. So again, if anything, that would just be a loose interpretation of a provision of a contract. And certainly it was stated to the court in such a way to make it appear as though it would apply to Savage in this instance, and we would obviously argue to the contrary. So for that reason, we asked that the court find that there was sufficient evidence for the jury to proceed with the notion of the right to contractual control.
Just two brief points, Your Honor. With respect to the HSE document, that is not a contract. None of the contracts in reference incorporate the HSE document in any shape, form, or fashion. But even if the court indulges that somehow the HSE could constitute a relevant type of contract, there's absolutely no provision in there that governs the use of or the operation of locomotives in this case. That was a general plan for safety, including, hard hats and that type of stuff, general safety requirements that has nothing to do with the relevant type of control in this case. And the case law is absolutely clear that the control has to extend to actually what proximately caused this accident. And so HSE documents are irrelevant. And the only way they sort of even backdoor get it to being relevant is they say, well, Sassel adopted or Savage had a site-specific plan, but that's a Savage document. And so again, that's not a relevant type of control because that's a Savage policy governing Savage's own work. You can't bootstrap that back into some allegation of contractual control because the actual independent contractor implemented its own policies. And then with respect to the lease agreement, again, it's irrelevant how Sassel and the Kansas City Southern Railway allocated responsibility for the construction of the premises. And again, when you look at actually the 14.6, which they cite, it says it's only in quote, in connection with this lease. And so the work that was being done in connection with that lease was the actual construction of permanent improvements on the property. And to make clear that it didn't extend to this type of work on chattels that were brought onto the property by other people, they included in section 1.1, it says, quote, for any purposes in this lease, references to Sassel's quote, contractor shall not include any service provider who installs, maintains, replaces, or upgrades any property belonging to such provider. So it's clearly allocating that we're addressing certain expansion work, and what we're not intending this contract to govern in any way is, personal property that's brought onto the premises, like the locomotive in question in this case. And I'd note that both the agreement with Savage that requires them to quote maintain the remote control locomotives mirrors perfectly with the maintenance language in this lease. The two, there's no conflict, and there's no statement anywhere in the lease agreement that the plaintiff or anybody else is a third-party beneficiary entitled to enforce any provisions in that agreement. No place does it ever reference enforcement of any of these provisions at all. And so they don't have standing to assert it, but even if they did, the contract doesn't say what they're trying to make it say. And so this is a legal issue for the court, and would respectfully request that the court grant a directed verdict on the issue of contractual control.
Opportunity to quickly respond. Just to directly respond to the notion that section 6.1.15, the contractor SHE, is regarding some type of a general safety rules. This section of the contractor SHE actually does specifically reference the Sassel general safety rules in another section. And they talk about in section 1.12 talks about the Sassel safety and health procedure. They identified the general Sassel safety rules in section 6.1.17, Sassel safety and health procedures, 1.6, general safety rules. For more information about general safety rules, the provision that we cited is not citing to the general safety rules. The provision we cited to is 6.1.15, where it says it is understood that all contractor safety representatives and safety programs are subordinate to Sassel safety. So that's not the section that they're referring to is not the section that we're citing to. And frankly, the jury has not heard the evidence presented in the way that it's being presented by him now. The way that this was always presented to our jury throughout this trial, and what they heard was that the safety rules that Mr. Francis was required to adhere to on the day of this incident were subordinate to Sassel. So the specificities that they are saying is required in defining the rules that we're to get the requisite amount of control, that specificity is in the site-specific language that we cited on page 6 of our briefing, where it talks about Mr. Francis being required to stand in a certain way, to ride the rail car in a certain way, to hold a certain amount of points of contact. All of that was subordinate to Sassel, who ultimately came here and told this jury that they knew that riding rail cars was dangerous. And we cited multiple citations throughout the trial record. That being said, including by a vice principal witness who came here and said that the entire purpose of bringing RCLs was to get them off the rail car. So that conflict is what the jury ultimately is going to have to decide in this case. That how can a company who was so adamant about moving workers from rail cars, know about workers riding rail cars while operating the locomotive, have rules that are subordinate to their safety that tell specifically how to do so, provide a switch list, do not provide the workers of the weights of the vehicle, and allow this man to be subject to certain slack forces on the day of this incident that he would never experience before causing this incident. So that's the reason why this is a jury issue, Your Honor.
The only final point, Your Honor, is a lot of that discussion involved actual control. So the whole issue of switchless, we briefed that's not a relevant type of actual control, but it also is irrelevant to the discussion of contractual control under the Savage Sassel Services.
Mr. Kathy, is there anything else on your motion, on Sassel's motion for directed verdict?
We would stand on the briefing on the other issues, Your Honor.
Anything else you'd like to add, Mr. Alfred?
Your Honor, we'll stay on our briefing for remaining issues as well.
All right, let's talk about Mr. Francis's motion for directed verdict.
Yes, Your Honor, we move for directed verdict on, let's see, let me grab that. See if that. What is this? Here it is, I see. Okay. Yeah, we move for the issue of directed verdict on the fact that Sassel owed a duty to Mr. Francis, that he was aware that Sassel was aware that employees were riding rail cars, to the fact that Sassel retained the right to contractual control, and to the fact that Sassel exercised actual control, and that the use of the RCOs was approximate cause to the incident, as well as they should have known that the workers would suffer injury and foresaw the general character of the injury. We also move for directed verdict as to the third-party defenses alleged by Sassel, alleging that Savage's negligence was they proximately caused the incident, as well as on the inferential rebuttal of sole proximate cause, alleging that Mr. Francis, his own negligence caused this incident. We provided a host of record citations in our affirmative motion for directed verdict, as well as in our motion against the defendants, inferential rebuttal evidence and their affirmative defenses. I will, for the fact that much of this has intersected with a lot of the arguments that we've already made, so leading this construction and the contractual control provisions, what I would like to bring the court's attention to is our motion with respect to their sole proximate cause defense. The sole proximate cause defense, the courts viewed such allegations as an inferential rebuttal, and that's going to be under the Walter versus Newton case. Also, there may be more than one proximate cause of an event, but if an act or omission of a party that's not party to the suit was a sole proximate cause, and no act or other of any other person could have been a proximate cause. Sassel, in this case, Your Honor, failed to establish that Mr. Francis's action or conduct was the sole proximate cause as to a matter of law, and they failed to raise any genuine issue of material fact regarding that issue. The evidence, as noted within our briefing, throughout our briefing, is that Mr. Francis was following the rules that he was trained to do. He was not aware that his company, in the weeks leading up to this incident, were making formal requests to move away from the remote control locomotives. Certainly, if he was not required to use a remote control locomotive on the day of this incident, he would have followed the rules just as he would have done any other day. But again, he was required to do what the work with the company was required, what Sassel was requiring his company to do out there on the city yard on the day of this incident. So for a jury to consider a sole proximate cause inferential rebuttal, we ask that the court find a directed verdict that there's more than enough evidence that it was not solely Mr. Francis' fault on this day of this incident, Your Honor. So I guess if the court would like me to move to the second issue, or like he did, just allow.
Let's go issue by issue on this as well.
Your Honor, I'll address the issue of sole proximate cause, which I understand to be the focus of it. The question of sole proximate cause is really a charge submission issue. Inferential rebuttals simply tell the jury that they don't have to find proximate causation. It's not an affirmative defense. It doesn't need to be pled. It's just an issue that in certain instances is submitted to the jury. In this case, so I guess I'll clarify a couple of points, but there's multiple different inferential rebuttals. I think new and intervening cause is probably the most direct and applicable one. That's the one we've requested to be submitted to the jury. But this issue of sole proximate causation is also meritorious and could support a charge submission because there is abundant evidence that the sole proximate cause of this accident was the acts of either Savage and or its crew members. And so there's, it's not as if, there is nothing to submit to the jury and no evidence to substantiate it. The plaintiff's argument is essentially that we require the use of RCLs, but again, that is not the actual proximate cause of this accident. We've argued this in the motion for directed verdict, and I think it bears repeating here, is a proximate cause is not a mere condition that made an accident possible. I mean, just because Christopher Columbus discovered America doesn't mean that every accident that happened after him was proximately caused by that discovery. And similarly here, use of the selection of RCLs 2 decades ago didn't proximately cause this accident. The things that caused this accident were the things that weren't required by SASL. That is, riding inside the gauge, not maintaining sufficient points of contact, whether that's 3 or 4, potentially cell phone use. All of those are the actual proximate cause at issue in this case. And the only people who controlled them are Savage and the plaintiff. And so the jury certainly would be well within their rights to conclude that either of those parties was solely responsible for the occurrence in this case. And so there is a factual dispute as to whether the plaintiff is solely proximate at fault or whether his employer is the sole proximate cause. And I would also note that I'm also sort of kind of confused as to the relief they're requesting. I mean, because it's also within the province of the jury when they allocate responsibility. They don't dispute that there is going to be an apportionment question, and certainly it's within the jury's providence to put 100% of fault on the plaintiff. So I don't know how you grant a directed verdict on the issue of sole proximate cause, yet still allow the jury to make a complete allocation of fault consistent with Chapter 33.
Anything further on that issue, Mr. Elford?
No, Your Honor, I think we'll stand on our briefing as to that issue, and I believe that it was just a great problem against that. Yes, and yeah, our argument I think was kind of subsumed. He argued against Savage and Mr. Francis being found solely responsible. I'm stated only as Mr. Francis, and I'll now state that Savage. That there's not any evidence of the duty that Savage owes to Mr. Francis, and that they violated that duty, and that Savage caused, that duty was causative of this incident. The case law is clear that when one undertakes to make something safe for others, he owes a duty to those to use care in making the situation safe. In addition to simple black letter law, Your Honor, that a duty to reasonable care must arise when a person undertakes to provide those services either gratuitously or for compensation. Our position is that SASL undertook the responsibility to ensure that Mr. Francis was safe by requiring this remote control locomotive device, requiring that it be used over the objection of Savage, and in doing so, failing to ensure that Mr. Francis was safe in its operation, falls squarely on SASL. So our position is that when Savage went to the SASL and said that it was untenable for them to continue doing the remote control operations within the city yard, that at that point by SASL refusing to allow them to do so, it became SASL's responsibility to make sure that was safe. And again, the slack forces and the buff forces that caused this incident, Your Honor, was solely based on the makeup of the train consist, which was solely in the hands of SASL on the day of this incident through their switch list. So our position is that there has not been sufficient evidence to place the responsibility onto Savage.
Your Honor, I'm again kind of confused by this position as well. Essentially, as I understand it, they're saying SASL had some negligent undertaking, and therefore that negates Savage's responsibility. First, they haven't pleaded a negligent undertaking theory, but even if they had, and even if you assume for sake of this limited argument that there was some negligent undertaking, that doesn't discharge others' independent obligations that they owe independent of that duty. There was no negligent undertaking because you can't have a negligent undertaking for a failure to act, and that's really what they're alleging. But even if you assume it is, the train wasn't, quote, solely in Sassel's hands. The plaintiff literally had the controller in his hands. I mean, he was the one who controlled the slack forces and the operation of the train. He's an employee of Savage. They clearly had independent duties. And the fact that, maybe a decision decades ago was made to switch to remote control locomotives doesn't forever negate everybody else's obligation to operate those locomotives safely and place duty and responsibility and liability solely on Savage, which I think is what their argument is regardless of how negligent the trains are operated or regardless of what anybody subsequently does, Sassel is solely and individually liable for every type of misconduct that somebody may engage in with respect to remote control locomotives. They don't cite any case law to support that. I don't think any exists, and it doesn't even withstand common sense, Your Honor.
Your Honor, we actually did cite the restatement second of towards section 323 and also Torrington Code versus Stutzman. Your Honor, the point being is that we do not see that there has been sufficient evidence to support their allegations that Sassel or Savage, that Savage or Mr. Francis would be solely responsible for causing this incident. And we'll stand on our briefing on the remainder of it.
Any other issues you want to argue with regard to the motion for directed verdict?
No, Your Honor, we'll stand on our briefing for the remainder. Yeah, and just to a point, that's a good point my co-counsel brought up, Your Honor. And we did affirmatively move as to contractual control. I think the record is replete. The court remembers specifically that this was a common theme as for the reason for Savage's request to move away from RCLs being denied. Their reasoning for it was, we have a contract. We have a contract. We have a contract. That's the record is replete with that. We've cited it multiple times throughout our briefing from the trial record. So again, as to contractual control, the way in which Sassel exerted its control and responded and the specific reason for rejecting the request to move away from remote control locomotives was because a contract is a contract. So that would be our affirmative motion as to contractual control.
Want to respond to that at all?
Nothing beyond what I've already articulated. The type of control was that they provide a certain piece of equipment. That's necessary in absolutely every commercial engagement. You need to at least tell the independent contractor the general type of equipment that is going to be necessary for them to do their work. The contract provision at issue is for them to supply a general class of equipment. That doesn't equate to control over the actual selection of the specific piece of equipment or what is really relevant, how you operate that piece of equipment. That is the granular and narrow type of control that Texas law requires that's completely absent in the contract. Contractual control doesn't exist in this case, and the court granted directed verdict in Sassel's favor on that issue.
Anything else?
One last thing, Your Honor. Simply requiring that a locomotive be provided would be general. Specifying that it be a remote control locomotive, which would take a conductor out of the seat, which would move the crew size from 3 to 2, which would require all of the multitasking that a remote control locomotive operator has to do, is much more specific than the case law that they cite or contemplate. If they had just simply stated, provide a locomotive, then a general argument would work. But they told them specifically what type of locomotive needed to be used. And when they came and said, well, hey, let's go conventional, which would be placing control within Savage's wheelhouse to say that we're going to use a locomotive, but we're going to switch to conventional, they were shut down because a contract is a contract. So that to me is the clearest indication of how contractual control was exerted on Savage throughout this case and in the weeks leading up to this incident.
Okay, I'm going to take a brief recess. I want to look into something on contractual control. If you will hang out here, I will get you rulings on these in just a few moments, and then y'all can maybe take a break and talk about the charge and how those rulings impact the charge.
Thank you, Your Honor.
Judge,
Um, yeah, yeah, um. Um. No, it's lunchtime. Because my connection magic has not been working like, and we're doing the church conference and, what's her name, like my file has not been, sharing. I don't know why, like, I tried calling. Yeah, okay, I'm gonna share it one more time. Let her know it's up. She said, of course, we couldn't just have a nice, easy day, exclamation mark. I know. Oh, do we know the authority? She's just telling. No. I, no, I think that she should run it through, hold on. Okay, looks like my file is working. So I think that she should run it through Copilot or ChatGPT or something to make it sound a little more professional, because like, I mean, it's good that she typed up the email and like, she said everything just copy and paste it into, like Copilot, and then just tell the AI to refine this email for professionalism? No. Okay. Okay. Okay, sorry I couldn't be of more help. Yeah. Okay, all right, I will, okay, and thank you, you too. All right, bye. Testing, testing, 1, 2, 3. Testing. Does that work? Hey, Mary, hey, I'm so sorry, I thought I would give you a quick call to ask you, how would you prefer that I send you the, my files from this morning? Like, do you want me to just put them in Dropbox, Google Drive, or email them to you? Okay, sure, yeah, I'll put them in, I can put it in the backup audios one, but it'll be, both my ECL files as well as my Opus files. Yes, yes. There are gonna be three. There are gonna be three, yeah, I tried to share them with you while we're on the record, but it just was not working, so I restarted my laptop while we're on this brief break. And so it seems to be working now, and I hope that it stays like that. I'm so sorry, I'm not sure what happened. But I'll go ahead and drop them in the drive. Yeah. Of course, and when you need tech support, they are consistently never there, so. Yes. Yeah, and I think, I know, right? I think what might have been the issue was I had my headphones plugged in for a few minutes while the connection magic file was up, and so I think maybe somehow that like interfered with, I don't even know what happened, but just so for your purposes, for your edification going forward, yeah, if that ever happens, like it could be, you know, if you work with another reporter, like it could be that. No, I know that it's just, we're gonna talk about the charge. I I'm not aware if we have any other motions that we're gonna take up, but so far it's just been, motions for directed verdict. And now, once the judge comes back, we're gonna talk about the jury charge. So I'm not sure how much longer we'll go for today, but I can double check in the evening. Ah, yes. Right. Totally understand. Yeah.
With all my glasses.
Absolutely, yes. What time do you need to get out? Okay, for sure. Let me double check with my judge and I'll let you know as soon as. All right, thanks, Mary.
Y'all can be seated. Thank you. What are you testing?
What's that?
What are you testing?
Oh, do you see it written up there?
Technical issues this morning, huh?
It's, oh, gotcha.
Just like ours, and then- So, ready, Abby? All right, I've had an opportunity to review both the motion for directed verdict that was filed on behalf of Mr. Francis and the one that has been filed on behalf of Sasol Chemicals. I'm going to grant a directed verdict with regard to the gross negligence claim. I am denying the request for directed verdicts on all the other issues. With that said, do you all need some time to go and talk about your jury charges?
I think that'd be helpful, and maybe a little time to confer in light of this and then confer together.
Take however long you need. I'll be out here. Just come and get me when you're ready to move out.
case, we would request that we begin with a question about Sasol chemicals.
Okay, I will leave question number 1 as it is proposed by Mr. Francis.
Thank you, Your Honor. Your
In
Honor,
terms of the sequencing.
In terms of sequence, yes. We'll talk about the control issues. Well, maybe that's not this question. Well, maybe it is.
Your Honor, I think the other difference, well, there are a number of differences, but the next kind of meatier difference is how to phrase this question. The formulation we have is, did Sasol Chemicals exercise or retain some control over the manner of how rail cars were moved within the city yard, other than the right to order the work to start or stop, or to inspect progress or receive reports? This is out of the PJC, and what the PJC says is, there's a phrase in there in brackets called injury causing activity, and it wants you to kind of describe the injury causing activity. And the way we have described it is the manner of how rail cars were moved within the city yard, which we believe encompasses the evidence in this case.
And Your Honor, we respectfully disagree. In light of the court's ruling on the directed verdict on contractual control, we don't have any objection to the exercise or retain language, nor do we object to the some control language, because that is from the PJC. However, the remainder of that clause, over the manner of how rail cars were moved within the sit yard, we believe is inappropriately vague and inappropriately confusing and overly broad. There is only one theory of liability in this case. It relates to the manner in which Mr. Francis operated the remote control locomotive, which is our competing language for that phrase. That's the theory of negligence that has been properly presented to the jury with evidence. There are a million other things that go into the manner in how rail cars are moved around the sit yard, from the throwing of switches to the coupling of trains to any number of other different things, none of which are part of the negligence allegations and the negligence evidence in this case. And I will note, going back to the directed verdict argument, any reliance on the switch list or this slack theory by virtue of the composition of the train cannot justify plaintiff's language in this question for a couple of reasons. One, there is no evidence that Sasol did anything to establish the composition of the train. Sasol simply asked for certain cars to be put at certain places. More importantly, that's never been established as a proper theory of liability by any expert. No one has testified before this jury that the switch list was somehow negligently put together, or that Sasol committed negligence in the composition of the train that proximately caused this injury. The only evidence relates to a theory of ultimate causation, that it was the slack force that ultimately caused Mr. Francis to fall from the train. But there is no negligent theory properly before this jury dealing with anything other than the operation of the remote control locomotive. For that reason, following the PJC's guidance in defining, if the court elects to define the injury causing activity, it should be limited to the operation of the remote control locomotive as is submitted in defendant's charge.
Your Honor, if I may respond briefly.
Sure.
So we have defined the scope of control here over the manner in which Justin Francis operated the remote control locomotive on the occasion in question. Essentially, they're trying to limit plaintiff's case to how Mr. Francis was operating it on that day using that remote control locomotive. But the theory that plaintiffs have presented is that dictating or controlling, mandating the use of the remote local locomotive, that's the negligence that proximately caused the injury. And so to adopt their formulation would basically unnecessarily limit plaintiffs' theory and closing argument when the evidence has been much broader.
Well, Your Honor, I heard all the evidence. The evidence was limited to remote control operations. And if I may clarify a misstatement I made, without our additional instructions, we are going to object to the sum control standing alone without additional instructions. And we are going to, just for the record, request instructions on contractual control consistent with the directed verdict rulings of the court. Again, nothing changes the fact that their language is impermissibly and vastly broader than the evidence in this case. We're not trying to restrict plaintiff's case. We're trying to have the jury charge reflect what the evidence was. There was no evidence of negligence by Sasol outside of the use of remote control locomotives. Their language clearly on its face goes way beyond that.
Let me look at the PJC for just a second.
Your Honor, it would be 66.3.
I've already got it pulled up. Thank you. All right, the PJC seems to indicate that I should substitute particular activity or work. So I think I'm going to have to select one of these. I am leaning toward Sasol's definition or instruction, but I want to look at the case law that's cited here. So I'm going to defer a ruling for a little bit on that.
Yes, Your Honor. And Your Honor, since you've indicated that you're leaning towards Sasol's definition, whatever definition the court ends up using, we request that it not limit the plaintiff so that the jury thinks, well, it is about how Mr. Francis, pressed the button on the remote control, but it understands that it's about the control in dictating remote control locomotives instead of conventional locomotives.
Do we stand by our submission?
Okay, I'll get you a ruling on that shortly. What other questions do we need to talk about where we have issues?
Your Honor, I believe there are a number of instructions that the defendants have proposed. We have responses and we can go through them line by line or however Your Honor would like to take a position.
All right, where are the instructions?
Uh,
Which
Where do you
one?
want to start? Okay.
They're on defendant's question number 2, which would be the comparable question. They have a kind of paragraph instructions.
I don't have any instructions on the one that, on the version I have.
It's on the defendants, Your Honor. You don't.
I can approach with a
Do
copy.
you have do you have a copy with you?
Yes, sir.
Just so I can make sure we're on the same one?
There's a whole paragraph of them that should be there.
Thank you.
Page 6, Your Honor.
Okay. All right, which instructions do you disagree with?
Your Honor, we disagree with all 3 of them. And I'll kind of explain our reasoning. First, the PJC doesn't require any of these extraneous instructions. And so we'd rather just go with the PJC formulation without extraneous instructions. But if we had to go through line by line, on the first one, it says with respect to the operation of the remote control locomotive, the control must extend to the means, methods, or details of the operation, such that Justin Francis was not free to do the activity in his own way. The 2 issues I have with this specific instruction is, first, the formulation of with respect to the operation of the remote control locomotive. It again focuses the jury's attention on the operation on the day of, rather than the control imposed by defendant in requiring remote control locomotives. So if the court is inclined to grant this instruction, Your Honor, what I would propose